All right, everybody, welcome to our webinar tonight. We have Ferd here with us, who will be doing a presentation on raising capital legally, the right way to do it. We're very excited to have Ferd on. Many of you know Ferd already, so he needs no introduction, but I'll give him one anyway. Ferd is the mobile home park lawyer. He's also practices law in many other functions as well. We all love Ferd. He's very active in our community, sharp guy with with a lot of great things to teach us tonight. So everybody, welcome Ferd. Ferd, I'll hand it off to you to get started here tonight. Thanks again for being here.
All right. Well, thanks, Michael. Appreciate the opportunity and a nice introduction. I wish my wife said as nice of things about me as you and Ryan do, but I'll take what I get, I guess. I'll try not to talk too much at you guys. This can be a really um, kind of confusing space for a lot of people. So I'll give you some high level stuff, and then I can show you a couple exhibits and things like that. But then also we can do as much Q&A as you guys want. So just high level, raising capital, what is it? I mean, typically raising capital is when you need money for a deal and you don't have enough of your own money, or maybe you have enough of your own money, but you don't want to use your own money. There's an old adage about OPM, other people's money. I know a couple of big time guys used to say that the two key rules to business were don't take no for an answer and don't use your own money. So if you don't use your own money or you don't have your own money, I mean, I was in a position early on in my career where I did the first few deals myself and they were going all right, but I didn't have any more money. So I had to choose. Do I want to stop working on new deals or do I want to raise money from other people? So I decided to raise money from other people. And there's a right way and a wrong way to do it. And if you do it wrong, you could get in trouble with the SEC. And it's kind of a big deal if the SEC gets in your business. And a lot of guys are out there doing it wrong. Um, Doing things, paying money finders and things like that that can be, felony charges for both the person paying the money and the person receiving the money. So the proper way to do it right is follow SEC guidelines. And the most common way to raise money is through a private placement memorandum. I say private because if you're raising money from others, it's a syndication. If I'm active and you're passive, so let's say Michael and I and Ryan decide to do a deal together. And Michael's going to do sales and leasing, Ryan's going to do property management and construction, and I'm going to oversee legal and budgets and things like that. Well, we're all active. We're all materially participating. If we're all active, then it's not a syndication. Now maybe I'm putting in 90% of the cash, and I got only a third of the ownership. Well, maybe I cut a bad deal, or maybe it's because maybe we value the day-to-day leasing, the day-to-day property management, construction management more than the stuff that I'm contributing. So you may have different split. That's really just a joint venture. Typically, you'll have that structure in a legal entity of a limited liability company. Depending on the number of factors, the state and the reasoning, and whether you want to. Most time you want to tax as partnership. Sometimes there's a reason to have a tax as an S corp. I can get into some of that. Um, but that's if we're all active. But let's say the three of us do two, three, four deals, then we run out of our money, or we find a whale of a deal that we just can't afford, and we just say, hey, you know what? I know 10 doctors that all have a lot of money, and they're each going to give us $1 million each. So we have $10 million of their equity. But the doctors have no material participation. They're just literally passive. Some people try to call it a joint venture or say it's an LLC, or they call them, they're investors or private partners. The reality is if we're all in the same LLC, we're all members. But if we're active, we're like the GP, the general partner. They're passive, they're a limited partner. And if those guys get a special rate of return, like say a preferred return, meaning say they get 8% on their money, and then after the 8%, we split it. GPs get 30, I get 30, they get 70. Okay, that's a syndication. Anytime somebody, because what I'm doing, if I'm not putting any of the money in, or even putting in a disproportionately low amount of money relative to my higher proportional percentage of ownership, what I'm essentially is happening is I'm getting paid for my services. Whether I'm getting paid a salary or not, I'm getting paid in the form of membership units or ultimately a portion of the enterprise. Well, if I'm getting paid and I'm active, they're passive, that's a syndication. Some people try to call something else, but it's not. It's a syndication. And if you're doing a syndication, you can do it public, like in the New York Stock Exchange. You can raise money from investors, or you can do private. Most people do private because there's certain thresholds of volume and massive regulatory burdens and compliance costs to be registered. So if you're private, you're not registered in the same manner with the SEC. So this comes from SEC law and code. I mean, ultimately, this thing came around in 1933. So under Reg D, The most common types of capital raising I see in the mobile home park space or mostly other real estate spaces is a Reg D 506B or 506C. The main I say B for buddy. So the 506B is like you can have some of your buddies in, but the key is you already know them. You have a materially pre-existing significant relationship, and they have to be either accredited or sophisticated. Accredited means they have an income of 200,000 a year for the last 2 years and an expectation for the current year. And if they're married, it's $300,000 a year. That makes you accredited. So if you're one day out of medical school, but you're single and you're making 201,000, you're not quite there yet. But if you do it for 2.5 years, you got 2 years, and then you're still got your job and you're making 201,000, you're accredited. If you're accredited, you can be in a 506B or a 506C. If you're not accredited, let's say you're, I have a buddy of mine that was in my first deal. It's a 506B. He was a real estate attorney. He was number one in his law school class. He got the highest score on the bar exam, and he got a job at a big time firm doing corporate real estate and finance. But he was not accredited because he didn't make 200,000. He made like 160, and he was not a millionaire. That's the other threshold to be accredited. You have $1 million net worth, excluding your personal residence. So if you got $1 million baseball card collection and you rent your house, you're renting an apartment or your house, you count as accredited. Well, my buddy, he is my buddy Steve. He's one day out of law school. He didn't have $1 million net worth. He had a negative net worth. He had all these student loans and he had 5,000 in checking. Actually had more than 5,000 because he actually invested with me and the minimum on the deal was 50,000. But as the syndicator, manager, sponsor, GP, those all vernacular all mean the same thing. Technically, you're probably a Class A member or a Class B member or a managing class member of an operating agreement of an LLC. But the vernacular we're supposed to say is I'm the sponsor, I'm the syndicator, I'm the one raising the money, I'm the one sponsoring the deal. Typically, the sponsor is going to be the guy that signs a bank note. Sponsor will be the guy that found the deal or is operating the project management, asset management, maybe also doing the day-to-day property management, and so on. But the sponsor is typically the manager of the LLC, and they have the control. Well, if I'm in my case with my friend Steve, I needed his money. I needed $750,000. I didn't have that kind of money. So and nobody's going to invest with me because they didn't know who I was. So I'm like, I can't go find random people on the internet. So I do what most people do. First deal, you use your own money. Eventually run out of your own money and you need to do friends and family money. If you're doing friends and family, they're people you already know. So you don't need to blast them on the internet. And the benefit of the 506B is you get to let in people like my friend Steve, who are not accredited, but who are sophisticated. I had to take the risk as the sponsor ascertaining whether or not I believed that Steve is sophisticated. Because of his background in education and intelligence, I thought he was. Like my little brothers, they're smart enough guys. They have master's degrees in teaching. They're teachers, but they're not millionaires, and they don't make 200,000 a year. So they're not accredited, and they're not sophisticated for this sort of opportunity. They have to be sophisticated in understanding the financial and legal risks of writing a $50,000 check in this type of investment. And the SEC ultimately put this in place because they wanted the people that were investing in these private placements to be able to, bear the loss in the event the deal is lost. If you make 50,000 a year and you got 5,000 checking, you can't bear the loss as easily as somebody makes 200,000 a year or is a millionaire. And if you don't have the thresholds but you're sophisticated, you at least are smart enough to in this realm to ascertain the risk. That's the benefit of the 506B is you can let your buddies in who are not accredited if your buddies are sophisticated. The main benefit of the 506C is you can e-blast it on the internet. You can market it. I had somebody one time, I never even spoke to the guy. I have a podcast. I had on my LinkedIn, I'm saying, hey, we're raising money for deals. Let me know if you're interested. This guy just shoots me an email. Somewhat out of the blue. I mean, I never talked to him before. And he says, hey, I listened to your stuff. It seems like you know what you're doing. I got 250,000 I'd like to invest. Send me the paperwork. And the guy signed the paperwork and wired me $250,000. I found that guy because of my marketing and online presence. I'm allowed to do that if my offering is a 506C. If it's a 506, once I've marketed, I can never go back to a B, and I can never let in the sophisticated. On the 506B, you can let in up to 35 sophisticated investors. If you guys have questions along the way, feel free to pop in, raise your hand, or holler at me. Otherwise, I'll keep going. So that's kind of the first threshold. If I'm active and you're not, I'm a syndicator. I have to do a PPM. If I'm marketing it, I got to do a 506C. Structurally, the documentation is the same. There's like one or two different sentences. Other than that, it's the same. Now, part of the sponsor, especially in sophisticated, is I want my investors, and this is an exhibit to my PPM template, I need to do an investor questionnaire. And that's where I ask things like, Dear Steve, what do you do for a living? What's your education? What are your investment goals? If his investment goals are um, current term cash flow, but my deal is a heavy value and I'm not going to have any distributions for the next 2 years. It's meant to just push the value and then eventually will refi or exit with a sale. Well, I'm not going to meet his current term cash flow needs. So I need to kind of investigate him a little bit. So someone just asked a question here. So all these ads I see pop up for private money lenders are fake or not advertised. So people try to use private money lenders as a workaround. You can do private money lenders because you're not offering them ownership or security. They're just a debtor. But with some, I see guys, and I see regularly. Today it's less so, but 2 years ago, I would say half or more of all of the guys out there raising capital were violating SEC law, and they're just leaving breadcrumbs right there on the internet for the SEC to come bust them. Um, and there's a big capital raising conference I went to one time, and the guy's on stage, and he was talking about fund to funds model, and the way that he was describing it was essentially a finder's fee, paying guys to raise money, and it was a major SEC law violation. And he wrote a book on the topic. So then he now is doing like the apology tour. And no, my book was just like summary version, but the real detail, here's how we really do it. So somebody tipped him off that he's going to be target number one at some point. I'm an investor in a number of MH funds of other operators, and one of them is currently, I'm not gonna say who, but one of them is currently being investigated by the SEC. And this guy's a major operator, major player, and his investments aren't going that well. So, but you wouldn't know it. The rest, most people wouldn't know because he doesn't give you that impression. But he's going under in many respects. So is another big group. I just heard one of the huge players involved with bigger pockets. I'm not gonna say who, but I just got wind through the grapevine that one of these big guys is his whole enterprise is going under. He's just been raising money on top of raising money. So the way that people are getting around it now, or trying to get around, the way people are trying to save their deals, especially the apartment guys, the way they're trying to save their deals is they're bringing in pref debt or pref equity. They're bringing in another tranche rescue capital, and it's just bringing in more debt to try to get them out of hock so they can buy a little more time so they don't have to get a foreclosure on their record or so they don't get sued as quickly. But private money lenders are okay within reasons. It's unrelated to this. It happened to they happen to come up oftentimes together. So what's the PPM? It's basically this big scary document that tells you everything can go wrong with the deal. If you've ever bought, if you have like a stock account and you're buying Coca-Cola, they're going to send you a prospectus. They used to send them in the mail all the time. They're thick. A prospectus is like, here's everything go wrong with Coca-Cola. And it's like they've properly disclosed and warned you everything go wrong. Well, PPM is kind of like that. It's kind of like a prospectus. It's just going to have, maybe there's state specific disclosures like, hey, like I just bought a deal in Illinois. Well, there was rent control on the legislative agenda for Illinois. It got rejected, but I may want to disclose that there's rent control, or there could become rent control, or I may want to disclose that things like my financial statements have not been audited. My assumptions and projections are based on my opinion, and they may or may not be correct, and I may or may not be skilled. Um, I might not give this full-time effort. In fact, I'm not getting full-time effort because I have other deals, and I might have future deals. I might even disclose that I might have future deals that could be right across the street from this one that you're not going to be an investor in. I got different investors in that, and I'm competing against against them, and I'm on both sides. I might disclose that we that I own the law firm that is doing the legal services. I might disclose that I own the construction company that's doing the construction rehab, and so on and so on. Some of these are just really generic disclosures, like interest rates may change. So a lot of it's boilerplate. But you're just basically, it's kind of interesting when you're the syndicator because you're like, for me in particular, because I'm also the lawyer, be like, hey, invest with me. It's a good idea. Oh, wait, but here's a document telling you everything can go wrong with it. So for you guys, if you're not the lawyer, what your job is to say, hey, invest in me, and you give them a pitch deck or an offering memorandum, and you say, but it'll say like all the detail disclosure, all the details are in the PPM, and then you go, oh yeah, my lawyers are making me give you this big document, you got to fill it out and sign it, read it, get your own legal counsel, all that. Very rarely do people actually, I think, read it and hire legal counsel. They just kind of trust the sponsor, in particular in 506B because they know you personally. So other things that are in the document. You're going to typically have like a summary, like here's the summary of the offering. I'm offering this. Here's the company name. Here's our compensation to the managers. Like, hey, on my deal, I'm taking a 5% acquisition fee. You're getting an 8 pref, but then I'm getting 30, you're getting 70. Maybe I'm taking a debt guarantee fee, a refi fee, a property management fee, an acquisition fee, disposition fee, project management fee. Maybe we're going to reimburse my affiliate property management company for X, Y, and Z. So just disclose your compensation as the manager or sponsor and disclose your affiliates. Some of you may not have affiliates, some may. And then you want to try to talk about the capitalization, like, hey, here's the amount of debt and equity. And maybe there's other tranches. Maybe you got tax credits or tax incentives. Maybe you got seller finance, second position debt, so on. And similar to the risks, there's the disclosure of notices. So much notice like in this state, I'm supposed to tell you this. But there's just other disclosures. There's like the risk factors, like, hey, here's the structure, the management, tax assumptions, et cetera. Typically, you're gonna talk about your financing, not just like, hey, we got a 70% loan, but we got a 70% loan from Bank of America, and it's 5% interest, 5-year term, 20-year MO, principal and interest payment. You're going to talk about the property management. Who's the manager? If it's you, disclose it. If you're going to plan to hire third-party management, you should probably disclose that. Business plan, kind of here's our goal. Here's where, this one, we're gonna cut down the dead trees, demo the bad homes, repave the streets, infill, sub-meter water, so on, so on. Where's our business plan? And then there's a distribution plan. This is pretty important. And there's actually like several different sections of distributions, like distributions that if we sell, distributions based on operating cash flow, distributions based on refinance, and distributions based on liquidation. And there's typically a waterfall. And the way the waterfall typically works is, first you got your mortgage and your operating expenses, taxes, maintenance, insurance, and mortgage. If there's money after that, the next dollars will go to the preferred return typically. And then if that water, let's say it's you got $1 million of equity and you've got an 8 pref. Then you've got to pay the first 80,000 of distributable cash flow to the members. The first 80,000 goes to the limited partners, LPs. After that, if you got a 30/70, if there's another $100, it goes 30 to the GP, 70 to all the LPs distributed. It's called pro rata and pari passu. So at the same time and proportionally to their ownership interest. And then you get different hurdles. You get more sophisticated in this, and you get a really good opportunity deal. You may put another hurdle in there. So, for example, I had a deal in St. Charles, Missouri. The structure was I raised like 850K, and it was 8 pref to the investors, 50 to me, 50 to them until I hit a 15% IRR, and then it went 80% to me, 20 to them after that IRR, that additional hurdle. Well, that deal we ended up selling it a lot faster than I thought. We had a really good opportunity. We bought it for 2,725,000. About 20 months later, we sold it for 5.2 million. So we made quite a bit of money, but we made it very quickly in 20 months. So my investors got their 850, the 8 prep we were paying current right out of the gate because the deal was cash flowing well. We paid the investor when we sold. So then we paid the investors their 850 back. And then we paid off the mortgage, and then we gave their money to their investors back. And then we had something like $2.5 million laying around. Well, because of that, I quickly hit the IRR hurdle of 15%. So that only took another, I don't know, $80,000. Well, then the rest of the 2.5 million was distributed now 80 to me, 20 to them. So by having an extra hurdle in there, an extra split, which was disclosed, which was in there, was in the offering memorandum, the pitch deck, it was in the PPM, it was in the operating agreement. And the operating agreement is not there's not a regular basic operating agreement. It dovetails with the PPM. So a regular operating agreement may be like 25 pages. The PPM is 100 pages. The PPM's operating agreement is 85 pages. So very complicated document set. Like we sell some of our templates. I think in this group, I gave Michael our template PSA to give to you guys for free, but we regularly sell that for $500. I don't sell the PPM template. I did for a while, but the people were messing up so bad. Like it's too many moving parts. I'm like, I'm not gonna sell that template because then we're both gonna get in trouble with it. But so it's relatively complicated. Well, distributions are key, waterfalls, hurdles, all that jazz. And if you can structure it however you want, it's all part of the negotiation. Same with the fees. You can charge whatever fees you want. You just got to disclose them, and you can't change them after the fact. As a manager, I have a ton of discretion. I can paint all the houses purple, and the next day I can paint them all pink. My call. You can't stop me. You're just an LP. But what I can't do is say, hey, I told you in the PPM the management fees were 5% of gross revenue, and then I decided 2 weeks later that's going to be 95% of gross revenue or 99.99. That's going to be some sort of fraud or misrepresentation. You can't just change that. Other things in the document, you got to reference, are you allowed to have certain transactions with members or managers? Like, are we buying this park from me, from my other group? Well, that's got to be disclosed. The one group that's getting investigated by the SEC, that's one of the claims, allegedly, is that they're buying parks cash themselves, and then they're selling them to our fund at a significant markup. And they didn't disclose that, and that wouldn't be appropriate, obviously. Other things that you might reference as they're pending litigation. You can talk about what's the offering price. Like the offering price is where we have a minimum offering and a maximum. Like on my first indication, I had a minimum offering of 750,000 and I had a maximum offering of 2 million. And the reason was I didn't know if I was going to yet get approved by 21st Mortgage because I'd never been in the program, and you can't get approved until you apply, and they won't let you apply until you send them a copy of the deed. So I'm like, well, I can't own it yet. So I'm like, well, if I get approved at 21st Mortgage, I'll bring the homes in with their money. But if I don't, I need another 1,250,000 to bring in the homes. So I'm gonna need to raise more cash. Well, obviously, if Michael put in 50K and that was 50 into 750, he's only that fraction of the owner. Was that 115 maybe owner? But if I end up having to go to 2 million, well, now he's only 5% owner. So he gets diluted. So I need to disclose that. And once people subscribe, that's one of their exhibits to the PPM is a subscription agreement. Once he subscribes, he's committing to send me his money. And once I get to the 750 minimum, he's in. Now, if he subscribes for 50 and I don't get anybody else, he doesn't have to give me the 50. But if he subscribes for 50 and Ryan subscribes for 700, I'm there. I might not be at 2 million, my maximum offering. And if I do up to the maximum, they're both going to get diluted. But once at the minimum, they're subscribed. And if they didn't pony up the money, in theory, I could sue. I probably wouldn't do that, but you could. So part of that dilution is got to be disclosed. And then you just want to disclose what the use of the proceeds. Typically, this is your sources and uses. The sources are the money of bank and LPs. The uses are down payment, road repair, acquisition fee, legal fees, etc. Basically, is your budget. And then you're going to disclose what kind of investors are eligible. We already covered the types that are. And then any subscription procedures. You want to describe the units, description of the units, or where are they limited or not? If you have any conflicts of interest, those should be disclosed. You have a section on income tax consequences, and you can say like seek your own lawyer and CPA. I'm not your lawyer and CPA. And I mean, for me in particular, um, if I am a lawyer, I'm like, look, I'm a lawyer for the company, which is the syndication LLC. I'm not any of your lawyers. And even if some of these people are actual legal clients of my firm on other matters, I'm not your lawyer for this matter. I'm just the lawyer of this company for this matter. So go get your own. This is miscellaneous other stuff, glossary of definitions and exhibits. Carrie asked, what's the benefit of having a syndication versus JV? The key benefit of a syndication is it's the legal method to raise money from passive investors. A joint venture is if we're both active. Now, a lot of people say they're doing a joint venture and they've got a bunch of doctors and surgeons sending them checks. The doctors and surgeons, all they're doing is sending you a check. That's not a joint venture. You can call it a joint venture. You can call it a banana. Doesn't make it a banana. That's a syndication. If it's a syndication and you're raising money and you don't want to go to jail, you need to follow one of the either register publicly or register in one of the limited options of private offerings, such as a PPM. So I covered some of the key terms: minimum offering, maximum offering, project related costs. You got purchase price, project cost, debt and equity amounts. There's a minimum investment. You can make the minimum investment $1, or you can make it 25 or 50, 100. It's your call. And then based on that, you can have a unit price. I typically do $50,000 minimum. The unit price is 50,000 per unit. And then you talk about the splits, and then again, multiple splits or series, depending on series. Like if you're like my last fund, if you put in 50K, you got a 7 pref, and I can't remember the details. It's been a few years since I closed that fund. 7 pref, and I get 40, you get 60. If you put in 250K, you get an 8 pref. I get 35, you get 65. If you put in $1 million, you get a 9 pref. I get 30% after the 9, you get 70. And then I had another hurdles in there. When I hit 15 IRR, those splits changed for distributions after said IRR. Someone's got a question here. If we have a 2-legged transaction, meaning we have a first closing and then a second owner finance closing, can we write up the first at 2.6 and actually pay 2? I don't know that I follow that. Maybe you can articulate that. Michael, is they allowed to, I don't see any of these people, are they allowed to articulate that verbally or do,
I can bring Jeff to the stage real quick. Hold
yeah,
on.
let's do it. He's Google asking it. Make sure I'm following it.
Hey Jeff, you're on the stage. You want to ask that question live?
Can you hear me?
Yes.
Okay. What I mean is if I have a lender in first position and to make it work and they're fine with it, they already know what I'm doing, can I write the first up at 2.6 and then we have to have a second closing for the owner financing portion, but we're actually going to pay him 2 million. Is that possible?
So the seller's only getting $2 million for the property,
Correct.
but you're telling the lender that you're buying it for 2.6 with the goal of
Yes.
getting a loan for like 70% of 2.6.
Well, it'd be like 40 or 50%.
Um, that's unrelated to the PPM capital raising piece. Can you do that? If I was your lender, I'd say that's loan fraud and it's a felony. Um,
Okay.
so yeah, I wouldn't do it. I've seen people do it. Yeah, to be honest, I've seen people do that kind of stuff. But it's if you get caught, the bank could be a big problem. Um, and I'm trying to think what the bank's going to want to do. It's also, I don't know if it'll practically work because if you tell the bank you're doing that one first and you're telling them it's 2.6, they're going to send the 2.6 somewhere. They're going to send their loan proceeds somewhere and they're going to probably send it to the seller. Um, so you would risk, I don't know, like let's say you were going to do a 50% loan, you're going to bring 1.3 to the table and the bank's going to be 1.3. The bank's going to actually make sure that you put your 1.3 in and they put their 1.3 in, and they're going to send all of that to the seller. Well, then it's the seller. So I guess in that case, the seller's got 2.6. So you have a hard time convincing the seller to then drop it 2.0. I mean, you could have like a second, you could have like an amended PSA like in escrow. Um, but I think there's risk in a number of fronts there.
Well, the money itself would be going through a title company and wouldn't be going directly to the seller at first. So all that money, the 2.6, I will actually have to put up for the transaction, but he'll really only get two on
Yeah,
the owner.
you have to have the title company be kind of in on it to hold the money in escrow, and then the bank, and then for the deed to pass to you, so the bank can have a recorded mortgage, which happens simultaneously with the deed. I think that if you can get a title company to do it, maybe they will. But I would be if your brother owns a title company, you might be able to pull it off. But I don't think First American's going to do it. Um,
I'm gonna bring Carrie to the stage here just because
Okay.
that was a little bit off topic on the topic of PPM. So Carrie had specific questions about 401ks and using
yeah,
them
she
to
said I can't use my
drop into
401k
GPs.
or SDIRA for my own park I'm managing as a GP. Correct. Thing
Yeah.
is,
So I've heard a couple things, a couple things on this. So if I have money in my 401k that I'm looking to transition into a self-directed IRA uh for my own park that I'm managing as a GP, I can't do that, right? It has to go into an LP on a park I'm not managing.
no, I'm not 100% sure. I've got some investors in my deals that do invest through their self-directed IRA, but they're the LPs.
Yeah.
I don't know if you can do it on your own as a GP. I've never, I don't have an IRA. I did for a variety of reasons, but I'm not, so I just don't really play with IRAs very much, to be honest. So I don't
Okay.
think I can help you there. You can take IRA money as a syndicator, but can you do it from your own IRA? I just don't know that.
Yeah. It seems like a gray area, which to
My
me,
rec
gray areas are,
Yeah, my recollection is it's supposed to be somebody else's deal because the two guys that are investing with me, one's a CPA and one's a real estate attorney, but their core businesses is they flip office buildings in Chicago. I'm like, but they're taking their money and they're investing with me as opposed to their own deal. So my gut is, and they're both really sophisticated. So my gut is that
yeah.
is a wrinkle.
Okay. Yeah, that's what I thought.
No
Thank you.
worries. Okay, so keep throwing quick question if you want. Other things that are key terms you want to make sure minimum investment, preferred, what's the preferred return? What are the hurdles, the splits? How's the depreciation being allocated? What are the member ownership percentages, not just for distribution, but for ownership for boats? What items can you vote on and not as an LP? What are the prohibitions or manager restrictions? Super majority. Sometimes you need a super majority, like replacing the manager. What is it? What's the structure for replacement manager, et cetera? And then you want, again, disclose the fees, and then disclose the distribution structure. You may want to include your financial model. I typically do is Exhibit C, my business plan, and then the financial model. And then you want to look at your legal structure. I'll share my screen here if Michael, if it lets me, looks like it will. So here's a sample structure. I can send this to you guys if you want. So this is my syndication entity, MHP Investors LLC. It owns MHP Land, which owns the land. It owns MHP Homes, which owns the homes. And these are both 5 and 6. And this next page talks about some of the tax and strategy accounts, but I'll tell you here. 5 and 6 are single member entities, which means they're disregarded entities by the IRS, so they don't file a tax return. Their only member is investors. So if this one makes $10 and this one loses $2, the plus 10 and the minus 2 goes up to here. That's $8. These two are managed by a property manager. I could be the owner of that property management company. This is the one that would probably be an S corp if you have payroll and stuff, because you can get, there's different tax benefits if you have an S corp with W-2 employees and a certain level of payroll. The rest of these are going to be typically LLCs, taxes, partnerships. Within Investors LLC, I got two groups. I got a Class A member is the manager. In this case, it's quote general partner, 35% share after the pref. Class B members, hey, these are my accredited investors, and they're limited partners, and this is credited because I'm doing a 506C, and they get a 65. Sometimes I have a brand name LLC, like I've got Niemann Investment Group. This is the entity that's going to actually get the deal under contract, but it's going to assign the deal, assign the land to this LLC to 5, assign the homes to 6, and it's going to raise capital through 4. And it's going to be managed by my property management company, which is different as well. And then you can choose to hold I prefer to have my LLC name over here as the manager, but I'll hold my membership interest, my ownership shares in a different LLC, so that if I get replaced as manager, if I get kicked out as manager for some reason, or I make some big mistake as manager and I get sued, great, you guys can take over management, but you don't take over my ownership or my carrots over there. And this is a standard PPM on a simple deal. It's going to look more like this, just a winner land LLC, and you got John Smith as the manager, and maybe he's managed by Smith Capital LLC. This one here is off of, I made it generic for obvious reasons, but this is off of a deal we did, very complicated transaction. It was tenants in common. So these 5 different entities bought the property. They're ticks. Smith, he wanted to be the manager of all of them. So Smith's the manager. But on this one over here, he didn't have any ownership in this. There was Jay and Susie own money in their trust. They 1031 into the property as ticks. And then you got, so it's pretty complicated. But at the end of the movie, it's John Smith running this enterprise, but he needed to put together a lot of cash, so he sold some of his other properties. So he put an entity. Him and Kelly sold one. Here he sold another one. Here him, Kelly, and Mike sold one. He raised money from Jay and Susie, but their money was coming from a different real estate deal, so they had to be part of a tick. And then over here was his invest. This was his standard PPM. So in this PPM, here's where he was raising money from various investors, but he had to disclose that, hey, all of us money guys and gals, we don't own the property. We own an 87.9375% interest in the property, and there's going to be other entities, some of which are partially owned by John Smith, some of which are completely unrelated to John Smith. We just need their money to get to the total. I would need to disclose that these other people existed, and then a TIC agreement, and I'm not get too far in the weeds, it's not today's topic, but a TIC agreement is going to govern all this, and it's going to say that, hey, Jay and Susie, part of your money is going to get clipped every month by Smith Capital in the same manner as it will in a syndication, because Mr. Smith, he wants 50% off the top putting together this deal. I'll pause for a second because that's probably one of the more complicated org charts you've had to look at. What are our rates? Depends on the deal. PPM on the low end is going to cost you $7,500. If it's super complicated, you got a joint venture, and the average just probably comes out in the 10,000 range. I've had one be 20. Depends. Like this one on this org chart I just sent you, that was going to be more than 10 grand. it can be, we talk rates are anywhere from $300 to $600 an hour, depending on which attorney's working on it. And we got 5 of us over here. Are you able to talk about shared road agreements? Not right now. I might if we get time at the end. Let's try to stay on topic. Got a question for Eric. At work, wanted to post the following. 1, preferred equity. How does it work? 2, does someone have to be accredited or sophisticated to qualify? You have to be sophisticated. Yes, to be an LP, you have to be sophisticated or accredited, as I've already talked about. We've already covered kind of the hurdles and distribution. So hopefully if Eric gets watched the video, his questions been covered or will be covered even more.
Ferd, I think the question was more directly towards if someone joins as a preferred equity investor, would they then have to qualify as an accredited investor, or is that different than being like a straight up LP with,
Well, so the term, I don't like the term preferred equity. I call it preferred debt because that's kind of what it really is. Because preferred, people use the term, they call it mezzanine debt, preferred equity, preferred debt. It often means the same thing, but it doesn't have to be. It's kind of like if I say a 2x4, well, what does that mean? Does it mean it's 2 inch by 4 inch, or is it the modern 2x4 you get at Home Depot that's 1 7/8 times 3 3/4? Both are called a 2x4, but they're not the same thing. If you go to renovate a house from 1900, you see what a real 2x4 looks like. It's a lot bigger than today. So can they come in some sort of debt or different than regular member structure? They typically wouldn't have to be. It's not as regulated like that. I don't think it's not. It's crystal clear that they have to be accredited, sophisticated. It's kind of like a private lender is how I think of it. If you know, that's kind of what you see now on this quote rescue capital, which is just a fancy name that these private equity guys call themselves. What they used to call them is loan sharks or hard money lenders. That's what they really are. If you ever read the legal docs, you'll know why I'm saying that. But typically, so if you know you're going to do that on the front end, you just need to disclose that as part of your PPM that there's other people who are preferred equity. Most time, what happens is those come in later. So then it raises questions: did the sponsor have the authority to bring in preferred equity or preferred debt later? And can they lend to themselves and all that kind of stuff? Would it be easier putting these properties in a trust than having the ownership divided by beneficial interest? I don't think that's going to solve this. I don't think that's going to address the core issue. The core issue is, am I raising money from passive investors? And if the answer is yes, syndication, then I would do the PPM. If the answer is, hey, I don't know Jeff, so we don't have a material pre-existing relationship. I know Michael, I know Ryan. If Michael, Ryan, and I each decide to kick in money, we don't have to do a PPM. We're all actively working on it. Maybe we don't own it 1/3 each, and that's because we have different skills or responsibilities. And we may even want to list as an exhibit to the operating agreement. Here's the roles and responsibilities of each person, which helps paper the file that we're all active. And you can't have 37 of us and claim we're all active on a mobile home park. Like, what are y'all doing? It's really like, okay, who's doing what? So I don't think the trust thing is a good example. Is there a size you recommend for newer investors who are looking to buy their first park? Size in terms of lot count, purchase price? I mean, that's super particular to each individual. I mean, everybody loves to buy 100 sites plus, but if you got 60 grand in checking, you'd be a hard time buying a 100 site park. Personally, I've bought parks as low as 16, as high as 153. I bought 25 parks, but average is probably 80, but probably, I got 3 or 4 over 100 that distort that average up. And like today, at this point in my career, I'm not buying 16, 18 site parks, but if I had 18 site park across the street from my 42 site park, I might buy it. So that's going to be a little subjective. Next question here. How best to involve non-accredited and non-sophisticated friends and family, particularly ones who don't want to take an active role? If they're non-accredited and non-sophisticated, they're not allowed to be in a 506B or a 506C. So then you got to say, hey, look, you got to get you something material to do. What are you good at? Okay, you're an electrician. All right, here's part of your role. During DD, you're going to go check on all electric pedestals. And I want you to, when we got to find, contractors, electricals, kind of like other contractors, I want you to be in charge of finding the asphalt guys. If they don't want to do anything, and they're not accredited and they're not sophisticated, but here's what most people do. They just break the law and they just put them in there anyway. I'm not going to recommend that, obviously. Here's what you should do is say, look, if you're not accredited, not sophisticated, and you're going to do zero work, I can't make you a membership. I can't make you a partner. You can, but I need some equity. I tell you, I was going to raise, 300,000, or I was going to raise 3 million of this $10 million purchase price. Tell you what, why don't you just lend me 100,000, and then I want to raise 2.9. Now, if I lend it to you, typically a lender, how's a bank get paid? Points and interest. They don't get paid if the deal becomes a home run. And typically they get paid before the equity. That's probably negotiable. You gotta, you can have more than one lender. You can have a second position lender, et cetera. And how to syndicate deals that you want to hold forever, structuring call options to buy out investors versus finding investors that want to stay in the deal forever, et cetera. That would typically be something that you could put a provision in there that I can buy, like my fund, I never done it, but I have the right to buy one of my own parks. And if I do, I just disclose it, and I buy it at the appraisal price. So it's a fair price. Similarly, I could say I can buy you out, but at what price and at what terms and when and so on. Or I can just negotiate. Like I've got a really good property, my first syndication, and I wanted to buy out my big investor, and they said no. Well, I can't just like make them. I wish I would have thought about it back then, that I had the right to, and buried it in the document somewhere. I would have should have disclosed it anyway, but they actually read the whole document, so they would have probably caught it anyway. But yeah, it's a problem. So I only have investors in at this point less than half my deals, because like I'm under contract on a really good opportunity. Not sure if we're gonna close on it. If we do, I'm not bringing investors in, because I think the deal will make $10 million in 3 to 5 years, and then 15 in the next 10 years. Well, if I can make $15 million, I'd rather not give away 70% of the deal or 50% of the deal. But I got to have the cash to buy it. So I've been saving money and moving stuff around, sold some stocks, sold some Bitcoin, things like that, because I want to buy all of this new deal without other people coming to the party. And there's some business problems with that. I had one deal. I don't cherry pick deals if I'm already got an open fund, though, because then it's like people are like, what are you cherry picking deals? So I closed my fund. I bought the next deal without investors. But if I have an open fund and I've already subscribed capital, that's on a multi-asset fund, which I haven't covered yet. So a multi-asset fund is, sometimes I call it a blind fund, because if I'm going, normally you go fishing for a deal, you get a deal, okay, you reel it in, now you got 60 days to close, you got to hurry and raise the capital. Well, if it's on $1 million deal and you got a good pipeline of investors, that's not a problem. But what if you stumble across a $10 million deal and you need 3 or 4 million bucks? It's gonna be hard to raise 3 or 4 million bucks in one escrow period in 60 days. So what I did was I launched a fund and said, I'm going to buy deals that, here's my last 5 deals. I'm aiming to buy 5 deals that look like those, but I don't have them yet. But if you subscribe, you're committing to, send the money in, and I had 18 months to raise the money, and I had 18 months to deploy it. And then if I didn't use it all, then I just say, well, sorry, you gotta have the liquidity laying around. Now, if it's in your stock account, not that big a deal, but some people are like, I don't want to leave the money laying around. So there's pros and cons. The pro of the blind fund is, if I got the subscriptions, I'm going fishing with bait. The con is, it's harder, in my opinion, to get people to invest before they know what that next deal looks like, because they can't see the pro forma. There's no pro forma. We don't know the deal yet. They can't drive by. They can't choose the market. I had one guy, he subscribed, and I had a subscription, and I found 2 deals, one in Iowa and one in Illinois. I go, hey, we're gonna put these in the fund. It's time to call your money due. I'm calling your subscription. Send me your cash. He goes, okay, but I want my money to go in the Iowa deal, not the Illinois deal, because I like Iowa better. And I'm like, you're not following. The fund already owns 3 deals. And then you subscribe, the fund's going to own 2 more deals. You're going to own a piece of all 5, including the deals that are already going. So if you get a first deal in there that's performing well, you can say, hey, join this fund. It's already, up by 2 touchdowns at halftime. And the opposite could be true, obviously, as well. Let me get back to my notes real quick, make sure it isn't, I like the questions, but make sure nothing really important that I miss. We looked at the structure, kind of that org chart. And to put a PPM together, you gotta, there's a whole bunch of data, I would need to get from you, name, address, and then all these disclosure items, like what do you think your splits are, your fees, etc. And then I could help you, form some of that up. But then you got exhibits, things like an operating agreement, a subscription agreement, a business plan, a new member signature page. Typically you may want to include your term sheet from your bank, or any relevant exhibits, like I got a phase 1 or a survey or a zoning letter or architectural renderings, things like that. And then there's an investor questionnaire. That's where you ask them, what are your investment goals? What's your income, net worth, career, education, et cetera. And then typically there's gonna be a property management agreement. And then if you're foreign investors, is another piece for that. I've never taken on foreign investors, but some of my clients do. And then after you raise the money, you're supposed to file, even though it's exempt from registration, you still have to file saying, here's why I'm exempt. And I went through a 506B or C, and then you do that on what's called a Form D with the SEC. And you're supposed to file with all the states. A lot of people don't because they don't want to pay the state fees. So it's free to file with the Fed, other than you got to pay the legal fees to get the work done. But it's the states charge fees anywhere from $0 to $500. And if I raise money from 5 people and 4 of them are in Kansas and 1's in Missouri, I got to pay Kansas times 1 and Missouri times 1. I don't pay anything in the other states. In some states, they take the position in most states, you have to file, they call them blue skies laws, state securities filings. Some law firms, I'm not one of them, but some law firms take position that you do not have to file to states if you've done the PPM correctly, because the PPM is federal. Another topic I'm going to hit one more time, then we'll go back to the questions. Money finders. People ask, what if I have someone else raise the money for me? How can I pay them? The most time the answer is you can't, and you both go to jail. There's one you can. The workaround is if they're a licensed broker dealer, like Merrill Lynch or JP Morgan or somebody. So I've been offered numerous times. I have some foreign doctor. I'll send out an e-blast. Hey, I'm raising $1 million. Some foreign doctors say, I can raise all it for you from me and my doctor's group. What's my cut? How much of the co-GP do I get if I raise the money? I'm like, that's against the rules. I can't just give you shares to raise money, and I can't just give you cash to raise money. Now, there is discussion. It's actually next week, I think, that the SEC is opening up for comment, considering allowing you to pay money finders, which would be a huge deal for people with big network. Now, I'm probably not gonna go do it myself just because I don't want to just sell for the highest dollar. But I could, like, let's say Michael was raising money. He goes, hey, Ferd, I'm having trouble raising money. You got a big network. Can you raise money? I'll give you a 5% commission on every dollar you raise. If he offered that to me today and I said yes, we would both be committing a felony. But starting next week, if it gets approved, I might be able to do that. And I probably could make some good money saying, hey guys, call me and I'll help you raise money for your deal. But for my own character, I'd only want to do it if I really understood the deal and believed in the deal. So when I've raised money before, I'm like, hey, I'm putting my money in too. Things like that. If raising money is part of your role and you're in the deal, that's okay, but it can't be like you're specifically all you do is raise money. So a lot of times you'll see people like, oh, I'm the investor relations person. Okay, I'm drafting the marketing, I'm drafting the newsletters and reports, I'm reviewing the financials. Okay, you're getting closer to like I'm really participating in this thing. And there's no like hard line. It's just you're supposed to be materially participating if you're part of the co-GP. And you can't be like just an introduction. I'm raising money. Hey, go here. Go. I'm raising money for Michael. Go talk to Michael. He'll tell you about the deal. I can't even spell the deal. If you're a co-promoter and you're a GP, you get an issuer exemption. Like if Michael and I are actually both partners on the deal and we're both working on it, and I'm raising the money, okay, well I'm part of the deal. I'm exempt from pain, so to speak. Any workaround scenario should be highly scrutinized. Okay, that's the high level. There's a more minutiae here, but that's the key. I know we got about 10 minutes left, so I'll go back to the questions here. Let's see if I can catch up on them. How do you price the new LP interest versus original LP investors in a fund when property is purchased in different time? Typically, it depends on how big the frame is. I know there's one big MH sponsor. He's not a client of mine, but I see his stuff online because I don't know how he's got it drafted in his document. But what he'll do is say, look, I'm raising 10 million. If you put in, if you put in 50, 250, 100, you get these splits, and they reward the guy that puts in a million. But they also say of the 10 million, the first 3 million gets a 10% premium. So instead of an 8 pref, they get an 8.8 pref. Instead of a 70% distribution after the pref, they get a 77 or whatever that is. So it's just disclosing it and then marketing it. For me, I've always had one of two things. My original syndications, I just did, look, for every 50,000, you get a unit. And I don't care, and we're all going to close on July 31st. So your money's basically all coming at the same time. The next level of difficulty I do is, okay, you get this for 50K, this for 250, this for a million, and it's going to all be in this time horizon on a multi-fund deal. It's in an 18-month period. So they came in different tranches. Really, it was just, you know, the first guy when I did that first fund, the multi-asset fund, I had, call it, I needed 500,000 for my first deal. Well, I already had 1 million subscribed. Well, so signing up early got you in the first deal. So the other 500 guys had to wait for the possibility of deal number 2, which in that case did come, but may not have. Okay, more specifically, if the first deal in the fund appreciated, the new investors expect the new investors expect the new investors are on par with them. So there is a provision in the multi-asset fund that's like this. So let's say that Aiden, you invested in deal 1, and then 18 months later we got deal 2, and they're both the same size. So the guy, and you put in all the money in deal 1, and the next guy's putting all the money in deal 2. You're both going to be 50-50 owners of the LP portion of both deal 1 and deal 2. My operating agreement and PPM agreement for multi-asset deals says guy number 2, at manager's discretion, will pay 8%. 8% of its, let's say you each put in $1 million, 80K of your million goes to guy number 1. So guy number 1 gets this huge windfall. In my case, I bought all my deals in a close enough time period that I didn't exact that provision because the first few deals hadn't materially changed. If I, I'm actually I haven't got around to, I'm about to do a podcast on my 2 deals in Central Missouri where I bought them not knowing if I was going to be able to infill because the city said no. I thought I could win the lawsuit against the city, but I didn't have time in the closing. I didn't have time to file a lawsuit, so I had to either buy them or don't. So I decided to close on them because if I could not infill, they were still like a single. And if I chose not to fight the city or I lost the city, I would just sell the deals and I'd still make a couple bucks. But if I could beat the city, I could turn it into a home run if I can infill. Well, eventually I fought the city, I beat the city, and I infilled. I went from 50% occupancy to 100% occupancy in 2 years, and I made $2 million on the difference, and it became a home run. So if those were if I bought the deal with investor 1 at this low threshold and I turned into the big threshold, the infill, and then investors 2 come in, yeah, it's a really sweet situation for investors 2 because the deal is now more valuable. So what I would do in that case, but no, I probably wouldn't even let them in. I'd probably go back to the first investors and say, hey, at the same price, you guys might want to jump in here. Or I could probably do some sort of amendment to revalue or recalculate. It really doesn't happen that much in my experience where during the offering period, because you're not going to have like a 10-year offering period typically, because otherwise you got to have some more in there like an evergreen fund. If you have a 10-year offering period, people aren't going to want to sign up and subscribe. And like I'm committing to give you the money 8-9 years from now. So it's a relatively short window. I really haven't seen word in about 18-24 months. And it's the deals, and you're not closing on day 1 and you're not closing on day, end of year 2, but there's sometime in the middle typically. So the change in the world for those early phase assets is probably rare that they're significantly modified like that. Okay, other questions?
We got one from Eric here in the Q&A section, which is sometimes hidden. Are you paying interest on fund subscriptions before the capital is deployed? I brought Eric to the stage if you want to.
No, I'm not. That's a great question. I do not. I pay if I have a multi-asset fund and you subscribe today for 100,000 and I get 10 of you to do it and I got 1 million subscribed and I find a deal that needs 500 and 500, I'm only going to bring 5 of I'm only going to call due 500 of the million. That first 500, they're going to start earning their pref and getting paid their pref right away. Right when they put their money in. Or if they don't pay it, maybe there's not money to pay it, but they're going to accrue it, and maybe just they're not being distributed until later in life. Those first tranche will get paid. The other tranche, no, they're not. Now, some people write it up that way. You could, if you want to really induce people, say, look, hey, subscribe, I'll start paying you 8 right away because I'm paying you for the inconvenience. Now you got to keep the money in a checking or a CD or something. but then they're double dipping because they're making money on the CD and they're getting paid from you. So you can do it that way. I've not done it. I know one guy that has a huge amount subscribed, like $100 million, and he had to use it by like June 30th. He had to call it by June 30th. We didn't find enough deals yet, but he didn't want to lose it because if you have 100 million and then you don't use it, they're never going to invest you with you again. Is kind of the theory. So what he did was he's like, tell you what, I'm calling it due, and he's got it sitting in a money market at 2.5%, but he's accruing a -8 on 100 million. So he's out there fishing with some heavy bait, and he's super motivated to find a deal because it's burning a hole in his pocket. Okay, so a lot to throw at you today. The key thing to remember is you can't pay somebody a fee just to raise money. And the other key is if you're raising money from somebody passive, it's a security. And then it's a syndication, and then you gotta do it legally with the PPM. There's no limit on the amount of money you can raise, anything like that. You could do it for business transactions or real estate. Most of the time we do real estate.
Awesome. Well, thank you so much, Ferd. We're coming up at the end of the hour here. I don't see any more questions filing in, so we really appreciate the time you spent today. This was incredibly informative. We're going to turn this into a recording. It's on YouTube as a live stream and will be available as a recording as well. And it will also be a podcast shortly. So look for that if you want to listen to it again. Ferd, I just want to thank you again. I also just want to let everyone know that in the invitation that you received for the registration and after this call, there will be a link that you can click to reach out to Ferd. And Ferd is also sometimes and often active in our communities. So join our school communities, either free or paid, and you can find Ferd in there as well. We just want to thank you, Ferd. Do you have any closing remarks here about how to reach out to you?
Yeah, that's great. I saw another question here. Some attorneys have a flat fee to arrange PPMs. We're open to a flat fee. I just need to understand the scope. We used to do flat fees only, and then I had one where a flat fee was $7,500, and then it ended up being they were negotiating a joint venture at the GP level. There was, then we're modifying the contract, and ended up being, and then they switched all their terms around because they couldn't raise money as effectively. So then we ended up redoing it. So I learned, okay, do it by the hour. So yeah, you want to reach out to me, and the easiest way is to, my email address, Ferd at Niemann Law Group. I think Michael sent you the link there, but you can do that. And I can schedule a call with you. We do real estate transactions, contracts, leases, title review, survey review, bank docs, syndications, closings, CMBS type loans, seller finance loans, agency loans, legal opinions. So we do a lot of zoning research and work. I got a whole podcast on that with Michael's group here that we recorded last time. And then a bunch of other miscellaneous stuff. So and it's not just me, we got a whole team of people here. But yeah, reach out if you guys need anything. Thanks for having me on, Michael.
Absolutely. Thanks so much, everybody.